Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Kristine. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Kristine.
Hi, everybody, and welcome to the August 2025 edition of the Third Fridays podcast. My name is Kristine, and August is always a great time of the year here at Lois Law Firm. We're 1 month away from our firm anniversary, and this year it's actually going to be year 10. So I know that the powers that be and our employee experience team are really cooking up something good. But also August, for everybody that actually listens loyally every month, is one of my favorite episodes of the year. It's the mock trial finals. And so we have our best and brightest, our future stars coming together to really demonstrate how much they've learned over the course of 4 to 5 months, and hopefully able to use some of these lessons and concepts in their actual cases. So we're going to actually start with the paralegals, and our paralegal finalists today are Elizabeth David, Beila Berger, and James Milone. Welcome to the show, guys. So you guys have either went through this before. I think actually all of you have done it once before, right? Yeah, or not, maybe not like a full year, right? So why don't we just start there for everybody that's listening at home. How would you put this program into your own words, maybe versus last year, or, in terms of like how you approached it this year, we did hit record. So if you guys want to be mean to the program, like you can do so, I can take it. What did you think of it this year, from your own experiences?
This year, like last year was I just started working here. So this year I felt a lot more confident and like that I understood the material. Like I actually understood it. I understood what was happening. So it was a lot more interesting and I was able to use my brain more, I think. So yeah, it was better for that reason.
Okay. Yeah. You had a little bit more like time under your belt. So now you're here in the finals. What about you two, Elizabeth, James? Any feedback on how it's been for you guys over the course of the 4 or 5 months?
I think I would say the same. I think, Beila, you were a few months before me. So when mock trial started, I just started working with the firm. So I honestly was completely out of the loop. But with the time that I've had to learn and figure out, I definitely was able to put a lot more pieces together during the mock trial this time around. So that was really helpful. And overall, I definitely would say that I was able to put a lot into practice. So I enjoyed that.
And James, on your end, it's a little different for you three because you three were very vocal all year, right? Now being more experienced, what would you say you would kind of advise first year paralegals? We had some that did pretty well this year, right? But Elizabeth and Beila are saying that with that year under their belt, they felt way more comfortable. Is there anything to speed that up, or is it something that just you have to kind of take it with time?
I think time is definitely a huge component of it. Just the more experience you have, the more comfortable you're going to be. But one thing I think can kind of help that along is, especially this year with the mentor meetings, I just tell any first year paralegal, ask your mentor, like, what exactly can I say to speak up? Like, get an exact script. So you like, there's no thinking about like, hey, here's something you can that will definitely come up that you can definitely say that will give you the opportunity to speak. Yeah,
that's a really great point. Like, something is infinitely better than nothing, right? In almost anything in life, right? Like, something is infinitely better than nothing. And I think anybody who doesn't know what we do or know what it looks like, I think like public speaking can definitely be a challenge, even for attorneys, right? And I think that, that's a great point. Like just asking questions, get you an answer, right? Like, this is a great point. All right. Good lead-in, guys. Appreciate it. We're going to start with trivia, which is my favorite part of the show. It's not always the easiest. So I don't even know if our listeners like when it's like tough or, but essentially for everybody out there, we have 2 rounds of questions. There will either be a 1 point, 2 point, or a 3 point question at the finalist's choice. And then the finalist can also choose whether to take it solo or include the other finalists. Obviously, there's a risk if they include the other finalists, so the point values are doubled. Any incorrect answer is also going to subtract points from your total score throughout the season. So there's definitely been some different strategies undertaken over the years. So I'm interested to see what you guys decide to do. And we'll start with Elizabeth. So you can choose a 1, 2, or 3 point question and decide if you want to take it solo or go all play.
Okay, I will do a 2 point question solo.
Okay. A 2 point question. There are 5 questions in the 2 point bank. Which one would you like, 1 through 5?
I will take 1.
1. Okay. And just so everybody knows, right, just so that our lovely listeners do not get dead air, right, there is only 15 seconds to answer the question after I'm done reading it. Fair? Well, I mean, you guys don't have a choice, but okay. The question is, what were 2 of the things that the employees were arguing over shortly prior to the incident?
They were arguing over who was going to be getting surgery first.
Okay.
And who was getting surgery first. And
Okay, we'll give you half credit, right? So we'll give you 1 because that was definitely correct. So what I'm going to do for Beila and James is if you guys know another one, I'm going to repeat the question, then you're going to have to buzz in, okay? So the question is, what were 2 of the things the employees were arguing over shortly prior to the incident?
Did I buzz in?
So you guys can all see it in the chat. James got it a little bit
crap.
quicker. Okay, James, what was another thing that the employee was arguing over?
Who gets to file their workers' compensation claim first?
That's correct. All right. So you'll get 1 point, James, for that one. And that's how it'll go, right? So next we'll go to Beila. We have a 1, 2, or 3, solo or all play.
I'll do 2 as well, solo.
2 solo. So we have questions 2 through 5 remaining.
I will do 2.
Number 2. Okay. What is the importance of the insurance policy limits of the civil defendant's insurance carrier as it relates to the workers' compensation claim?
Well, their maximum limit was $100,000. So in terms of Section 29 rights and risk transfer, there's a max amount that they'll settle for and a max amount that will it'll like lower the amount that we'll be able to get as a lien, pretty much.
Yes, I'll give you that one. The maximum amount will limit how much we get, but it won't lower it, right? So like the higher the value is of the civil settlement, the more we'll get. But you did get what I was looking for, which is in terms of getting the max recovery into the workers' compensation claim. So that is correct.
Yeah, like percentage will be lower.
That goes 2 points for you, Beila. And now we'll go to James for your first round question.
All right, I'm going to do a 3-point question.
3
By
points?
myself.
3 points solo. So you guys are going solo on the first round. Got another 5-question bank. So which one would you like, James?
Let's go number 3.
Number 3. Okay, we're not looking for an exact date here. According to the labor market attachment proofs, when did the claimant first start looking for work?
According to the labor market attachment proofs, the claimant started looking for work.
Okay, that was a tough one. But since you didn't answer, you won't have any lost points. Beila or Elizabeth, I'll read the question again. If you guys have an answer, you can try to steal the points. And the question is, according to the labor market attachment proofs, when did the claimant first start looking for work? You would like to buzz in? Oh, Elizabeth, you want to take a guess? What do you have? Oh, you're on mute. These are the
February 12th.
February 12th. We're going to take that. We would have taken the easiest answer, which was prior to the accident, right? So that was the weird thing that we had in prompt 4, where we're litigating labor market attachment, and someone posed the question, was like, so you started looking for work before this accident even happened, or what's the deal with that? All right, so Elizabeth, you'll get 2 points for that question, and now we'll go into the second round. So you guys now have the hang of it. Elizabeth, your second round question, what would you like?
I will go for a 3-point question.
Okay, and number 3 is off the board, which you stole and got, but 1, 2, 4, and 5 are remaining.
I'll do 5.
5. Okay. So the question is, what was the freckles order of the prompts chronologically in this mock trial season?
We had first.
Remember, if you don't want to risk the points, you don't have to answer it.
Okay.
Okay.
No answer.
All right, so I'll read it again. What was the freckles order chronologically of the prompts this year, Beila or James? For a buzzer. It's like frantically looking at notes. What was the order? Okay, so the order was controverted. We had the pre-hearing conference. Then we had the settlement negotiation with our adversary. Then we litigated fraud. Then we litigated labor market attachment and the surgery. And then today here we're doing risk transfer. All right, tough question, but nobody gets any points or loses points there. Beila, your second round question, what would you like to do?
I'm gonna stick with 2 and solo.
2 solo. So we have 3, 4, and 5 left.
Okay. I would like to do 4.
4. Okay, the question is, when will a Section 29-2 notice need to be issued to the claimant as it relates to potty johns?
Oh, so the date of loss was 3/21/25, so we can do it 3/21/26.
Okay, that would be correct, but potty johns has already been sued. So that was the trick part of it, right? Section 29-2 is the subrogation notice that we would take from the claimant, right, if they don't sue the defendant. But since they've already sued the defendant, that would be correct if they hadn't sued potty johns. That was a tough one. But I do like the fact that you knew the Section 29-2 rules. So good on you. That would be the earliest possible time that we could issue that notice and take over the subrogation. All right, our final question of trivia. James, your final question. What would you like to do?
I'll go 2-pointer.
I'm sorry, what was that?
Two.
2-pointer and solo or all play?
Solo.
Okay, solo. So nobody went all play. I actually like that strategy with you guys. So you guys are really killing it already. 3 or 5, James?
5.
5. Okay. The question is, who were the mock trial participants that earned more than one prompt prize for best performance in their category? The mock trial participants who earned more than one prompt prize.
Rachel as a mentor.
Rachel as a mentor is a good guess. She did earn one prize for being a mentor. Shout out Rachel Shapiro. She did not earn more than one. So Elizabeth or David, I'll read it. Elizabeth or Beila, I'll read it again. Who are the mock trial participants that earned more than one prompt prize for best performance in their category? Elizabeth.
I hope I get this right.
I do too.
But I think it's Beila.
Oh, that would be interesting. Beila's shaking her head. She did not win more than one.
Okay.
That would be so funny if Beila did win 2 and she didn't know to guess herself.
Oh my God, I wish.
So the answer is nobody. The first year ever. This is season 9. This is the first year in mock trial history that we've had a new winner in each prompt, in each category. So really just proud of like the depth of talent we have at the firm. So I do like the guesses, but James and Elizabeth, you'll lose 2 for that one. But that does it for trivia. We'll be right back with our attorney finalists. Okay, and we're back at the Third Fridays podcast. My name is Kristine Cintron, and for our second segment, we actually have our attorney finalists here. In third place currently, subject to trivia, we have Jacob Gilbert. Welcome to the show.
Hello again, everyone.
And in second place, we have Elizabeth Pappas.
Hello.
And in first place, Natalia Verde. Welcome back to the show.
Hi, everyone.
So you guys worked with paralegals for most of the rounds. And obviously, I mean, I guess in theory you could speak to them for the finals, but you've been mostly on your own. What was it like working with paralegals that were on the more experienced end of the spectrum, like those who could participate and really contribute, and those who were there to really learn and get their feet wet? What were the differences that you faced in, working within that type of a team structure? Any thoughts about that?
So for me, like when I was working with the paralegals, I feel like they asked a lot of questions. They were very eager to learn more. And while it may be like intimidating to actually speak in mock trial or anything, when we did our prompt preps, they were very adamant about structuring things, understanding why things were being spoken about the way that they were spoken about. And then ultimately all of them did speak when the prompt came on Third Friday. So at least for me, and I'm usually working with people who have less experience than I do, you did see a lot of drive to learn and try new things.
Do you guys feel the same way, or did you experience anything different as far as working with paralegals, especially since this was your first foray into it? Were there ever instances where a paralegal was maybe teaching you guys some things, or introing you to a topic that you hadn't dove into with as much detail yet?
I think it definitely did in my case, because I started mock trial, not even 6 months into the job. So the paralegals at times knew much more than I did, especially procedurally about how things work. And they were definitely the guiding force in a lot of the strategy and throwing ideas up against the wall. And so I really think that it was such a cool experience because they got to really get their hands dirty in the nitty gritty of things. And we got to test out arguments that we may not always be able to do when we're dealing with real client money because, you can't risk it to get the biscuit as much when you have hundreds of thousands of dollars on the line.
Yeah, it's fun to play with Monopoly money and just throw it against the wall, right? What about going up against paralegals? Like Elizabeth, you had some circumstances where you were arguing very aggressively against a paralegal, and you guys are all used to just beating up attorneys in court, right? What was that like? Was that something unexpected, or was that something that didn't surprise you?
Yeah, no, I was certainly surprised and impressed, by many of the paralegals. Again, I started mock trial 3 weeks into the job, and throughout the process, I would say that I learned a lot from multiple paralegals, and in fact, oftentimes I walked away very humbled. Not that, paralegals are, less capable. However, they just have a lot less training regarding the actual litigation aspects. And so I really grew to appreciate the role that they play more. And just, again, I was just wildly impressed at both the procedural and the substantive knowledge that they had regarding the law, even the new paralegals. So I think it was, to kind of tie in the fact that we're able to engage with people, both attorneys and paralegals, that we normally wouldn't meet with. Like, not only did I form quasi friendships with some of these people that I was working with, I gained a lot of respect for their knowledge and their ability to practice, I guess not practice law, but to practice the
who knows, maybe in the future, right?
Yeah.
Sometimes I do think it's a glimpse into not even really law school, because how many I don't know how many times do you have a law school activity where you're in this trial situation, unless you're actually doing mock trial in law school. You're in a skills competition or an advocacy class. But I think seeing that really makes me think there is a desire and a future for them to do what we do. And sometimes, we know how hard we've worked to get to this point and how much it's taken out of all of us mentally, emotionally, financially. So, it is a good step to see, and hopefully they can move forward with it. Okay. Well, thanks guys for that. The second segment is basically a pitch as far as an action plan. So to let all of our listeners know, we had an initially denied claim that was established by the board panel on appeal. So the carrier lost an appeal in that sense. But the board panel also found a partial disability, which led to further litigation about labor market attachment and a future surgery. So less than 30 days ago, right, July 3rd, Friday, we had a prompt where the law judge decided that the claimant was not attached to the labor market and that the surgery requested by the claimant's provider would remain denied. So in this mock situation, we don't know whether the claimant will appeal. We probably expect the claimant to appeal. And now you guys are tasked with, proposing to me whether I can be, the mock client or the mock attorney that's going to go in there and put forth your plan, what we should do, right? Based on everything that you guys have done to date. So if anybody wants to start, we can move forward with, your pitch, and then the other two can chime in. I'll ask questions here and there. But yeah, anybody has the floor. Elizabeth, you want to start?
Yeah, sure. Okay, so I'll just to piggyback on what
Can
you
I?
said.
Sorry for that. I probably should give the listeners more detail, right? Because like the actual prompt is the civil attorneys have submitted a demand of $2.3 million, but the civil defendants have only tendered a maximum offer of $75,000, and the claimants' workers' compensation attorneys, who are a different counsel than the plaintiffs in the civil arena, have made a demand for a full and final settlement of the comp claim for $100,000. So based on all those numbers and the status of the case, you guys have, I guess the pitch for what we should do. So sorry about that for cutting you off, but yeah, go ahead, Elizabeth.
Do you think like 3 minutes is fair?
You can speak. I might cut you off, or I might ask you a question, or these other two, Natalia and Jacob, might ask you a question or disagree with what you want to say. So it's not, I don't think you're going to be talking for 2 minutes, 1 minute consecutively at any point.
Great. So as you mentioned, there's potential for appeals. There's a lot of unknown factors here, but the reality is that in the civil claim, the policy limit is 100,000. So it's, although the demand is 2.3 million, the reality here is that 100 grand is the max it's going to settle for, which I think eventually will happen. And here we're looking at a case where we have increased leverage to settle our claim. Awards aren't running. The claimant was found to be unattached. The surgery wasn't authorized. And again, there still might be appeals, but the exposure here is going to be high. We have costs. You're looking at costs, including defending the appeals, IMEs, depositions, etc. So all that being said, even the best case scenario, since the claimant's average weekly wage it's still in question, the minimum for the date of accident is $325 per week. And at a minimum, if we were to continue to litigate this, a minimum LWEC of 1% would have a present value of $68,000 and change.
Okay, so let me ask you a question there, Elizabeth. You have, you're working with a case where, our mock client, the carrier, was successful at labor market attachment and denying a surgery. The claimant is probably going to appeal both of those issues, and you believe the exposure's high, right? So I know you mentioned that you have a very high floor with this minimum rate, but are you thinking that that the carrier is going to lose one or both of those appeals?
I think in terms of the appeal, we potentially will lose the appeal for the surgery. It's unknown whether or not they will appeal in the first place, but the reality here is that whether or not we lose on appeal, the litigation costs incurred with all of that in view of the policy limit of the civil claim, I think it's in our best interest to go ahead and settle this now and try to recover at least a part of the lien. If you want me to go forward with my recommendation.
So settle now, and leverage the successful result out of this. So to either Jacob or Natalia, do you agree or disagree with the proposal to settle this as soon as possible?
I would like to point out that if the claimant were going to appeal, wouldn't you think that they would do that prior to the mediation to walk into the meeting with leverage? Because they only have 30 days to appeal, and there's no telling how many days this mediation is after that decision was rendered. So if they're walking in, I'm assuming it's at least a week, if not more. They're eating up that time, and that's leverage that they could have had in their back pocket to try to strong arm a settlement.
That's an interesting point. I guess the claimant could just appeal to actually get the leverage, right? Like they have. Why wouldn't they do so already? But I guess to that point, Jacob, how many one-page RB89s do you see from claimants' attorneys who just kind of mail it in, right? Thinking that they're going to win.
Yeah, it's very simple, but that just shows to prove even more that if they haven't appealed it by now with the bare minimum effort, they're probably not going to seek an appeal for either of the decisions. But before it even gets to that, I think that we need to know the Medicare status of the claimant, because that could turn the settlement on its head. If an MSA is going to be required, that could be several $100,000. That could be a non-starter from the beginning.
I think that
risk transfer.
We already know that the claimant's Medicare SSD status isn't a factor right now, though. So that doesn't even have to be considered, which goes to the agreement that we should settle now before his Medicare status does change. And I'm of the opinion that they're going to appeal both decisions, both labor market attachment and the denial of the surgery. And they may win on both of those, which if I was Ezra Care's attorney, I would appeal labor market attachment. Even though you're not going to be getting any awards now, you could potentially backdate the awards for 6 months. So they're going to go for that, and they're going to shoot their shot on it.
That's interesting. Okay, so you think, Natalia, that they could potentially win on both of those issues, labor market attachment and surgery. So if we were to lose as the carrier or the defense counsel in this case, like lose both of those appeals, what are we looking at as far as, potential settlement?
I would recommend a settlement for $50,000, full and final, and asserting our lien in the third party action. If we want to be even more aggressive, we can settle for $0 and still assert our lien, but I don't think that's going to influence claimants' counsel in the slightest. I think they're going to be upset if we appear to a mediation recommending a 0 full and final settlement. I think $50,000 gets it done. I think you have, like Elizabeth said, a lot of leverage right now to settle it, but you're still gambling with the law. Elizabeth said that even at 15% LWAC, you're hitting a minimum of $68,000. So this claim is going to be worth that. But you assert your lien, you recover about, let's say they settle for $100,000, you're going to recover about $58,000. So all in, if you consider your prior awards and you're asserting your lien and you're paying the $50,000, you're looking at $100,000, about $100,000 all in, which for a neck and back case is reasonable considering where we're at. You still have to consider that surgery, which is going to happen whether it's now or down the line. It's about $20,000 alone for a lumbar fusion. So I think right now you take the leverage that you've built and you get a reasonable settlement before you have to continue litigating and having those costs of litigation as well.
Elizabeth,
I don't think that a claimant is going to accept a $50,000 settlement if you're not waiving the lien, because all you're going to do is call back that lien when the third party case settles anyway. So there's no money to the claimant, so there's no benefit to him doing it. And moreover, that's $50,000 in his pocket to fuel future medicals. Even if we're not paying for the medical expenses, it could later be money to fund the litigation costs and more surgeries and more treatment to make the third party case go from $2 million to $3 million or to $4 million.
Yeah, I would agree. And I have a compromise between the parties, if I may. Sorry, Kristine, I didn't mean to interrupt. So I've done the math, and I was thinking here, in the proposed closing statement, multiple of the expenses are unnecessary. I think we could whittle this down to $7,370.79. Okay, so we've already expended $104,000 and change. My suggestion is to agree to a partial lien waiver where we'd waive 20% of our lien. And so that would induce the claimant to and then what we would do is we would waive 20% of our lien, and then separately we'd offer a full and final Section 32 in the amount of $15,000. So that way the claimant would have a guaranteed $12,000 and change, plus the attorneys in the workers' compensation claim would be guaranteed an amount upfront rather than trickled out over a long LWEC period. And so everybody would come out winning here. Effectively, it would give the claimant the incentive to accept it, and that would cost you essentially, so the claimant would get $12,000. We would get $49,459 back on the lien. Claimant's counsel will get their 15%, and everyone comes out winning here. Because at the end of the day, it's the claimant's only going to agree to a settlement if the claimant knows they're going to walk away with something in their pocket. And so I feel like that's a good compromise, and that would really only put you out around $30,000 in the long run, and we'd still be able to recover $50,000 for our partial lien waiver.
Okay, but you did mention that we might lose at least one of the appeals. Natalia thinks we might lose both, right? Why would the claimant's workers' compensation attorneys take $15,000 as an offer if they've demanded $100K for some of the reasons that all of you guys have stated, right? Established for neck and back, fusion potentially authorized, LMA potentially reinstated. I'll toss it back to Jacob. You mentioned that the claimant won't even accept $50K if we're not going to waive a portion of the lien. What would your settlement proposal be if any?
Yeah, I think that we would have to work with the third party counsel, because a claimant's not going to settle the workers' compensation case as long as we have that lien. And if their third-party case is recovering the amount of the lien or less, that means that we're going to try to recover all of that, and they won't pocket any money. So I think that if we did a $0 Section 32 and we worked out a fee agreement with the claimant's workers' compensation counsel as well as his third-party counsel to make sure that the workers' compensation counsel does get compensated, because I know that's a red flag that can pop up and prevent the settlement from going forward. Even if it is in the best interest of their client, that's always a roadblock that we have to overcome. That would maximize the amount of money going to the claimant, because if the third-party case settles for $50,000 and we settle for $0 with the full lien waiver, that means that the claimant gets the full $50,000 less attorney's fees. Whereas if it settles and we try to claw back that money, even if we give them a $10,000 workers' compensation settlement, if we're trying to claw back any of our lien, they're going to end up with less money. So I think that's the great thing about this mediation is all the players are going to be at the table, and we can tell them, look, even though you're only getting $0 from us, you're not really, because you're actually going to walk away with way more money in your pocket than you would be if we had given you $20,000 or $40,000.
Can I tell you guys one thing that I love most about this is that with 3 separate answers for exposure value and a claim, it just warms my heart that I wrote something that doesn't have one answer, right? Like brilliant minds like yourselves have come up with 3 different potential outcomes, and that just makes me feel good inside that it's not just everybody has the same answer. Okay, so Jacob, your last point, right? We're gonna have essentially a $0 Section 32 and work with all parties to waive a portion of our lien so that the claimant's workers' compensation attorneys get a cut of whatever goes to the claimant in the third-party claim. Now, maybe the question I have for everybody here, in light of what their values are or their recommendations are, the claimant's third-party civil attorneys have demanded $2.3 million. Now, they probably know that they have to know that the civil defendant's policy limits are $100,000, right? Why would they demand $2.3 million anyway then? Like, what is the point of doing that? Is there any problems that you guys foresee with their office or maybe even the claimant themselves if you have a situation where $2.3 million is something that's just not going to happen? Like, is there a potential for something to blow up?
Sure. I think that it's clear that as of right now, they're not going to settle anytime soon, and I don't foresee that happening at the mediation. And in view of the exposure in terms of medical indemnity and everything we're looking at in the workers' comp claim, I think it's in our best interest to go ahead and settle, cut off our exposure, because, we're sort of talking about between the 3 different options that my colleagues and I presented today. I think we're all under the agreement that it's in our best interest to get out now. And so whether or not we're saving, $15,000 or $20,000 in the interim, I think that waiving a portion of our lien, entering into a very small Section 32 and cutting our losses is in everyone's best interest.
I think that it also should be a red flag that we should work with our client, both the carrier and the employer themselves, to do a deeper investigation into the file, because a number this high may not necessarily be unsubstantiated. Maybe there is an actual tortfeasor which would allow them to recover higher than the policy limits. And while that may not necessarily impact us on the workers' compensation side, it is something that could completely, cause mass upheaval in the future litigation of the claim.
Okay. Now to kind of put it all into perspective, right? We still have to know, what do we think is going to happen with this workers' compensation claim, right? Because aside from risk transfer topics and concepts, if there is a chance that the workers' compensation carrier walks away with maybe a neck and a back claim with a minimal LWEC, but no LMA and no surgery, maybe those recommendations that you guys have would be amended. So final question for you guys is, and just so that, you guys don't latch on to each other's thoughts here, is, what is this case going to eventually resolve at? What type of LWEC are we thinking? Are we going to have to pay this out by virtue of the claimant becoming attached to the labor market? And how long would it take for the claimant to reach MMI based on what you think is going to happen with the surgery decision on appeal? So there's 3 questions there, right? Like, what is the LWEC? When are we going to reach MMI, and are we going to have to pay out an award based on labor market attachment? So 3 questions, 3 finalists. Anyone that wants to go, just answer one of those questions, and then from those conversations, we can piece together how much the claim is going to actually cost the workers' compensation carrier.
I think that if the surgery is overturned, that could completely render the whole labor market attachment moot going forward, because while the current period that was already decided that he's not attached, that could have negative impacts if it's overturned, because then we would have to pay for the period. But if the surgery is authorized, then it resets the clock on MMI, which could be up to another year before he's found to have reached maximum medical improvement. And then we're going to have to raise labor market attachment again in that interim period. So if the surgery happens, or if the surgery is authorized by the board panel, then the whole clock resets. And that's why I think it's so important that it's settled now.
Some of that is true, Jacob.
Yeah, you also have a matter of bocce.
What do you have to, here. Before we get to even bocce, Natalia, right? Like, the question we want to answer is, what is the board panel going to do? And I know that it's difficult, to play, with a crystal ball here. But Jacob, if you had to answer the question, are we going to win or lose on the surgery being authorized? What would it be and why?
I think that we will win, because the board panel is really hesitant to overturn the fact-making decisions or fact determinations by the law judges, because they're the ones who are the arbiter of a witness's credibility, and they're the ones who hear the demeanor. They're the ones who actually, are in the hearings. They understand the history of the case best. And if the law judge didn't think that the claimant needed the surgery, I find it unlikely that the board panel would overturn that. And based off of that, my previous answer was more of like a hypothetical if it is overturned. But that's why I think that we need to do the $0 Section 32 again, is because I think that we're right at the end of the litigation in terms of the workers' compensation side. Like, there's no appeal. There's no indication that an appeal is going to be filed. We have no authorized surgery. There's no labor market attachment. So it's teed up for us to present that $0 Section 32, and I think that they would accept it as long as the claimant's attorney gets paid.
Okay. All right. So if we're going to win that surgery, then how does that, and to one of you guys, Elizabeth or Natalia, how does that affect when MMI is going to be reached, and, or if you want to answer the labor market attachment question, are we going to win on that issue?
I think you'd previously asked also about our LWEC percentage projection, which I'm happy to go over. So I would project it to be around 40%, which is 89,375, or a present value of 78,000 and change. So we have imaging that showed evidence of prior injuries, but you have to show recurrence of symptoms, no correlative imaging findings. And so I would project a class 2A, a medical impairment of class 2A based on table 11.1. So that gives you 16.6% functional abilities. The Marola report, the latest Marola report from April, showed that the claimant had difficulties in all aspects: bending, lifting, pushing, pulling, sitting, etc. She can't sit more than 20 or 30 minutes, can't stand more than 10 or 15 minutes, can't walk more than several blocks. But the claimant speaks English, is an electrician, likely doesn't have any transferable skills. So accordingly, that's how I came up with my $40,000. 40% LWEC percentage, which there your exposure again would be around $80,000.
Okay, and then Natalia, maybe whether or not you agree with, those last 2 answers, right? Bringing us home, right? Part of it is also a discussion of like, how much exposure are we going to face until the claimant reaches MMI? And then are we going to win or lose on labor market attachment? You did mention that we might lose both, but if you had to make a choice on the labor market attachment appeal, Where do you
I
think
always
you're-
err. I always err on the side of caution. Their attorneys are going to appeal both. It's in their favor to appeal both, so I'm expecting the appeal is going to be filed on both. For the surgery, I think it's going to be authorized. It met the guidelines. So I think that the surgery is going to be authorized, and if it does get authorized, which that puts us 6 months away. Like, let's say the appeal happens, we have to wait a minimum about 6 months to get the potential approval, which is going to then put us a year after surgery, so that you're already increasing your litigation for 2 years. That's just going to be added cost. You also run the risk of like bringing in new sites because you still have a right knee that might come in. There's been no PFME, but if the right knee comes in, then you have to consider the exposure for the knee. So you're opening up a 2-year window for just so much chaos to happen that can increase or decrease your exposure. But do you want to run that risk? I wouldn't. For a 40% LWAC, I would say that that's way too high. And then you also have the issue of apportionment because the claimant did have a prior injury. So how is that going to play into it? You have to consider too that like if we do settle this, we're going to have to get an apportioned opinion on that. And the labor market attachment, I think it might get overturned. That one I'm less confident on, but she did produce a lot of work search evidence. She did testify to speaking to people individually about job opportunities. I would say if you throw money at the claimant, you throw $50,000, you're within a reasonable amount of money to settle a claim that's for the neck and back. You also have an AWW that hasn't been set, but you're still running around numbers that are going to hit that max total rate of 1,170. So you're still hitting that max rate. It's going to be a high exposure. But then when you consider, 15% LWACs, or even let's say a 25% LWAC, you're at that minimum 325 rate. So I think 50 is fair. You still can assert your lien. It's probably not going to settle, but in the event that it does, you're still guaranteeing that you're going to be able to recover something from it. I think all in, when you consider what you've paid to date and what you pay out for a settlement, to close a neck and back case and avoid 2 additional years potential litigation, I think it's a no-brainer for me at that point.
This was really excellent, guys. I think you guys did really, really well in terms of like framing the issue and like putting a number on it. I don't really have notes for you guys because obviously the whole intention of the prompt is to create these different pathways for you to show, your CAPS values and articulate how you want the file to go, right? I actually have a different answer, but I don't necessarily think it's better or worse. It's just a different one. If it were me in your shoes or just like if this was a real case, I would actually authorize a full and final settlement up to the claimant's demand. I would say you can go negotiate up to that demand, $100,000, and worst case scenario, take it. And the reason I would do that is because I exert more control over the third party issues than I do over the workers' compensation claim, right? We all had these conversations about whether or not these appeals would win, what the LWEC would be, what the impairment, all that stuff, right? And we don't have the same degree of control. But if we settle the workers' compensation claim, and to the point that everybody made here and jumped in on was the $2.3 million demand and seeing if there were potential other defendants, right? I think that's a very, very valid point and very likely situation because the plaintiff's attorney in the civil case probably knows what those policy limits are as well. And so to make a demand anyway means that maybe this mediation is going to include a party that we don't know, or at least the express mention of another party that should be involved. So the reason why I would authorize that full and final settlement is because I can close my workers' compensation claim at all costs, right? Whether, obviously if we can get it down to, that $15,000 offer that Elizabeth, you mentioned, and whatever number we come up with, I want that case closed no matter what, right? And that's also a benefit of the success we have in the workers' compensation claim, right? When you get those double wins in one trial, you should immediately be thinking settlement. And so I would do that. And then knowing that there's another potential party out there in the civil landscape, I'm not going to waive any of my lien because I'm going to give this gift of $100,000 potentially to the claimant and say, you're going to get this, but I'm not waiving any of my lien when you settle against Potty Johns. So this $100,000 that you're getting is potentially what I would have potentially waived as part of the civil case. But I'm going to get back everything, every dollar, every penny from Potty John's settlement, because I know that if I really did want to make a partial waiver, maybe it would be in the future against this other defendant, right? At least push that can down the road and not force me to give up money that I have to do so now. So I take the thing I can't control, the thing that has not a 100% outcome, and I say, let's just fix that. Let's fix that reimbursement potential. Then I go to the other side and say, this is now my total lien, right? You're going to pay me every single penny from that Potty John settlement as part of Section 29. And if you want to go after a third-party defendant, go after it, right? So, but I mean, we've faced many situations, guys, right, as attorneys, where we make what we think is a bulletproof recommendation. But again, like Jacob said, we're playing with fake money here, right? And so clients will come to us and say, like, they have a directive, but they won't always tell us why, because those factors are not necessarily reasonable for us to even know. So I think what I want to end on with this part for you guys is that when you come to that conclusion, make it yours, make it confident. The way that you outlined it here today is exactly the way that I know you guys are doing in your reports, and to keep up the good work. So let's put a ribbon on segment 2, mostly for time purposes, since this did go a little bit longer than I thought it would, but very, very good banter and conversation from you guys. We'll be right back for segment 3 with our attorney finalists. Okay, and we're back for the final time, hopefully. We have the final segment of our mock trial podcast here at Lois Law Firm. And this segment is about the ideas for 2026. And, you know, we tinker with all of our programs and ideas, and we always want to make it the best so that iron sharpens iron. And, you know, having finalists like you guys here hopefully will make the program better than what it is today. So I'd like to welcome our 3 mentor finalists for this year's season, Dan Gillis, Alexis Cintron, and Kristine Rosales. Welcome to the show, guys.
Thanks for having us.
Thank you for having us.
So like as mentors here, right? Like you see the prompts come in, you know, every month, and you know that your role is to help, you know, a mentee, an inexperienced litigator really bring to life the ideas that you have, or inspire them to create your own ideas. So I guess the question that I have for you guys is, was it a real enough feeling case, like where, you know, you got a little bit of information, never as much as there is in a real compensation claim, a real docket, to kind of put together something that your mentees could understand? Or were there things within the prompt that you said, you know, like, I wish that there was this involved? Like, what were your thoughts on that?
I think for the most part, there was enough information that you had enough information to guide these participants in an effective manner. But obviously you can make reasonable inferences based on the information you have. I mean, I think there was one instance with the LWEC, and if you had given us the age, we probably could have taken that and ran with it.
Right.
Because you can extrapolate so much from somebody's age.
Yeah. Okay. What about you guys?
I would agree. It's funny that you mentioned age. I was thinking while prepping for this and just considering this case in general, specifically for settlement purposes, like if there was an outstanding issue of Medicare, knowing the age would have probably made us able to like streamline something to the client or something in the case, or value the case a little better. But overall, I would say like the information that we were given, at least for us as mentors, I would say gave us a pretty good idea, and we could relate it to our own cases that we've actually handled. So I think the information was like the perfect amount for a mock trial.
Okay. And then Kristine, or if you're still there, we've had some technical difficulties.
I'm here.
Okay, you're still there. Thank God.
There's enough I feel like there's enough loopholes in both sides, so we can make creative arguments for the claimant or for the defense, whichever side we're on.
Yeah, and also too, right? Like it always happens this way. Maybe because like I'm writing it so defense friendly that the claimant never really wins in mock trial. Did you guys ever get the sense of going through the materials that like, oh, the claimant has a decent case here this year
for the fraud?
Something.
I
thought he had a good.
I thought I warned the mentors, the participants. I said, don't be surprised if there's no fraud found.
Right. Okay.
I thought that was. Right. I thought that was it wasn't enough.
A weak fraud. It
was enough. It was a good faith basis to raise it.
Right.
But to get a decision was a reach.
Okay.
I thought that I thought he was going to be found attached only because of the efforts made for vocational rehab.
Right. There was a lot of vocal.
Yes. And the excuse of being like, well, he's not getting back to me. They're not getting back to me.
Right.
He didn't supply proof of that, but in experience in LMA trials, I've noticed that the minute vocational rehab is done, the judge is like, oh,
they're trying to better themselves.
Yeah, come on. How dare you, carrier? So I thought that was going to be, I was surprised when they were found unattached.
Yeah. And, Kristine, we're coming off of, your idea in this prompt where you're like, this case is worth nothing, right? Like, so at any point did you feel like the claimant had a good leg to stand on? Because maybe that is something to sharpen the tools is, if the claimant keeps losing, lowest mock trial, maybe he or she shouldn't. Maybe he or she should actually win, and we should focus on what happens after the fact.
So I feel like in the labor market attachment portion of the mock trial, the forms that were submitted were not the ones that were provided under the workers' comp board. And I was really thinking that the claimant will be found not attached because of the inconsistencies in the testimonies and the documents that were submitted. But I feel like there was enough arguments. I feel like there were sufficient arguments posed by the litigator to support labor market attachment in that case.
Okay. Just some thoughts, and as we get into your ideas, maybe we could kind of like come back to that. But every year, right? We asked, well, not every year, but like it's been a recent trend and tradition to ask, how can we make this better? Because that's what we do here, right? That's what we do every day, try to make things better. When your backs are against the wall in an industry where the employer and the carrier lose way too often, right? It's the creativity that really can help us move forward. So I'd like to start with you, Alexa, as far as your idea for 2026, and then you guys, Dan and Kristine, you can comment on it. You can and talk about it. We can make this a discussion. We'll get to your ideas in turn, but let's start with you, Alexa. What was your idea for 2026?
So I think there needs to be some, maybe not in every prompt, but some element of a surprise fact thrown on the participants, only because in our experience, it literally happened to me in a hearing this week. You're prepped for your hearing, you're prepped for your deposition. All of a sudden, you open the board file, there's multiple exhibits submitted. There's something that is going to catch you by surprise and possibly change your action plan. And I think to really showcase people's skills of working on their feet and how one fact can actually like change your argument, change your position in an instant, I think that would be a fun addition to the mock trial. It could also, obviously, depending on the experience levels, I know paralegals may not feel comfortable in a hearing if they don't know how to handle a certain thing, but it could be tailored to, I don't know, maybe the paralegals have to, a surprise subpoena response came in and they have to pitch the idea to the client a different way than they planned. But for an attorney litigator, proof of LMA was submitted the day of the hearing. How are you going to change your argument to the judge for arguing for suspension? Some element of surprise also gives, it's fun. It's fun to just see how somebody would handle it. And that's what we deal with day to day in real life. So I think that would be an added bonus.
See, and the reason I wanted to start with you is because we did that like a couple years ago, and I enjoyed it. Kind of like being a dungeon master, I guess. But like the idea of giving the surprise facts, we did that on the day of Third Friday years ago, and I think like it was something that had really good intentions, because we said we don't want you to spend so much time like prepping, right? We want to like showcase the skills that you have like when you're on your feet. You have to make a quick decision, right? And that could go from answering a phone call to being at a hearing on a deposition, right? You might have to write an appeal on the day that it's due because someone authorized it, right? On that particular day. And I think the chaos that ensued from it was so much to the point of it really pushed the grades or the skills towards experienced people, right? If you had someone that started, a couple months ago and say, hey, like, now you got to do this right now on the spot, I think that was a very tough thing. And so I wanted to meet, Kristine or Dan, like, do you think a surprise factor, because I mean, I love the idea of a surprise because it gets people out of like prepping and writing and, memorizing, but is there a world where a surprise could work in some case?
I mean, in a mock trial setting, I like the idea of a surprise, but as you pointed out, I guess it had been done a few years ago. I don't remember. I could see how it would gear towards more experienced attorneys that could handle it. But I think if enough time was given for that surprise, so you give the prompt, and I think it was like 2.5, 3 weeks before Third Friday.
Yeah.
If you gave them enough, maybe 5-7 days in advance, like, oh, by the way, this was just filed.
Okay.
The only added question I would have is, how does that impact any mentors?
Right. It's like, it's a lot of moving parts, for sure. I mean, maybe there's a way where, it's a surprise that is manageable in a way.
Sure. Yeah.
Not like a lower degree of difficulty, or like an issue that is a surprise but has like tiers of.
Yeah, I think it could definitely be, if it's planned and going into the mock trial that this is gonna happen, you could possibly tailor it towards experience level. Like if you, for instance, next year change the way the players of this game go, like maybe paralegals get a certain surprise, litigators, but that would just be depending on the structure of the mock trial. I would agree with Dan though that potentially some notice should be given.
Yeah.
Before.
So like not like a surprise, just like
not like going into the hearing.
You're gonna have a surprise party in 3 days.
Right.
Yep.
Yeah. It just adds a little pizzazz.
Right. Kristine, anything about Alexa's idea? Anything? Do you think that could work in some kind of fashion?
I love the idea of surprise because the paralegal litigators and the attorney litigators who will be facing this surprise facts or surprise witness or exhibits, they will have an opportunity to grow. Because when I attended a hearing before and I handled the labor market attachment, the claimant submitted the labor market attachment on the same day of the hearing, and the judge asked me to conduct a cross-examination on the claimant. So I was like, okay, it's always the first time to do this, and there will be also a first time for them to do that, and it will give them a chance to grow.
Yeah, those claimants, those sneaky claimants.
Awful. I can't believe they made you
something
ask
into the record same day. It's like a common occurrence, unfortunately. Okay. All right. So, guys, I guess then if there is a surprise element of 2026 mock trial, you guys will have Alexa to blame, not me.
Thank you. I'll take that blame.
All right, we'll move to Dan. What was your idea for next year?
It's much a surprise. I wanted to go in a different direction. I thought occupational disease claim orthopedic with potentially 2 competing dates of disablement, because I've had conversations with attorneys in this office, and that seems to be an ongoing change in the law, given the third department cases that are coming out, and it really heavies on fact-intensive nuance. And to Alexa's point about pivoting, and I think that's a really good example of when you're cross-examining somebody, whether it's a claimant or an employer supervisor or even a physician, like sometimes they give you answers you weren't expecting or you hoped they wouldn't say.
Right.
And then the question is obviously, with mentor guidance, how would you respond to that?
Yeah.
And I also think it introduces the coverage in a nice way.
Right.
That's a foundation of like, especially in the construction world, a lot of foundation is like, where was he last working? Who was he last working for? And whose policy is which?
No, it's not. When I read your proposal, I thought it was a cool idea, and then also, you could make it a surprise. Like, hey, surprise! This is an occupational disease claim. just use everyone's ideas.
I thought about the element of surprise would go into obviously the physician. I liked the idea of a willing participant to actually kind of give you that real, like God, who was it? A couple years ago with the video Connor did.
Oh yeah,
right, with the assault.
Yes.
Yeah.
I thought that was a good to actually have like a partners who can gauge, obviously understands that people aren't as experienced as him or her, but can still add some level of theatricality.
I would agree with that because that was my first year doing mock trial when Connor did that video. And I remember, I think the last prompt of that, throughout the whole thing, there were witnesses and then he was the claimant. He testified and he came in and it was, you had to work with what he was doing and you had to like base everything off of him. And I think that also added like a different way of approaching the questions and everything.
Yeah, I think like the materials were very sassy that year. And I feel like if we can kind of keep that level up, it'll certainly be a nice one. All right. We'll go to you, Kristine, for your idea for 2026. It's a certainly interesting and creative one. So I want to save yours for last. What do you think 2026 should look like for mock trial?
Okay, are you ready for this?
Yeah. I mean, I already know what it is, so I'm just excited. But.
It's called the Lowest Law Firm 2026 Mock Trial Madness.
And how would that go?
So this is similar to the March Madness, but the difference is that instead of using individual brackets, it will be a team bracket. So prompt 1 will start with 32 players, 16 players consisting of mentors, litigators, judges, and witnesses will compete against the other 16 players. The team that wins will advance to the next round, leaving 16 players for prompt 2. And then prompt 3 will start with 8 players, 4 will be competing with the other 4. Prompt 4 will start with 4 players. The 2 teams will have a chance to summon a teammate from the choice of eliminated players, and this is going to be the wild card prompt. And then the prompt 5 will be 2 teams comprised of litigator attorney, litigator paralegal, and a mentor who will fight head on. And then for prompt 5, there will be a bingo card distributed to the eliminated participants who want to place their bets on the combination of individual players that they want to win.
I mean, I love this idea, right? I think my question for you, Kristine, is how would you keep people involved if they're eliminated early?
That's a good question.
Right? Because
right.
I think that like the stakes would be very high, right? Mm-hmm. But what if, like, for example, you have someone who, wants to keep pursuing and for whatever reason their team like loses by a point or something like that. What can we do so that they remain involved the next month, even if they're not like formally competing in that second prompt?
I mean, they can speak with the members who are still playing in the game, and they can try to convince them to include them in the 4th prompt, the wild card prompt, so they can still take part even if they were already eliminated.
And you guys can tell me if I'm being too crazy here. When I was thinking of that like roadblock, the initial solution I had would be everyone votes on the team, right? So it's like the participants also vote and like say like, okay, this team did better, so that even if you're eliminated, you still have to watch and see like the process play out, and you have to explain like, okay, this person did better because of X, Y, and Z, ABC, and so that maybe if you're not performing, because there are also a lot of people that don't do mock trial for the public speaking aspect, right? And I think that they can still feel part of a team while also seeing like how it's not actually that difficult and that bad, right? I think like that first step in any public speaker's like progress track is actually public speaking, right? Like once you do it and then you do it again and then you do it again, it's not as hard as it was. And so to get them involved could be something where they have a say in who wins. I think that, and then the crazy thing is, I don't want it to become a popularity contest, right? Like, you just vote for your friends and all that stuff, right? But there is some momentum to that idea. I think there's just a little bit of tweaking that has to happen so that we can make it perfect. But what do you guys think about that?
I like the initial concept of the March Madness. It's more of a sort of like NFL rules, like single game elimination here. And I had the same question to you, Kristine, about keeping engagement. I mean, there could be something maybe working out some sort of I don't want to call it a consolation, right? Because you want to still have them vested in the participating. Yeah. So if there could be some kind of, I don't want to call it 2 tracks. Yeah. Like winners go
like a double eliminate, or
maybe something like that.
Yeah, like the people who don't advance have their own separate tournament. Maybe that could be a thing.
Yeah, but I feel like that could be splinter out a little too much for you.
Yeah.
I feel like that keeping people involved, maybe you could make, if they're eliminated, you could still reserve them for like a mentor role of it, of like, how would you guys handle this if you were still competing? And they still get like participation credit for still being involved in the mock trial. That is a way that I think they could still consider being involved.
Okay. Yeah.
I think a good workaround for this is those who are eliminated will have a chance to participate in the next prompt, but not as litigators, maybe as witnesses or as judges.
Oh, okay.
So they're not really like eliminated with no role. They're still going to be part of the madness.
Oh, okay.
That makes sense.
That could be part of it too. All right. So there's I guess like all of this is now more work for me. But no, these are 3 great ideas that I think we can kind of like. I'm interested to see the other 6 ideas we have, and maybe we can make something that's really special for next year. But that does it for the mock trial finals. Thanks for all your hard work. And so for Kristine Rosales, Alexa Cintron, and Dan Gillis, my name is Kristine Cintron, reminding you to defend from day one.